Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Involuntary Manslaughter Lawyer, Chicago, Illinois. If you're facing involuntary manslaughter charges in Chicago, Illinois, you're likely dealing with an overwhelming and uncertain situation. Even though involuntary manslaughter doesn't involve intent, it is still a serious felony that can carry severe penalties, including significant prison time, potential fines, and long-term consequences for your future. At Combs Waterkotte, our manslaughter lawyers bring over 8 decades of combined experience defending clients against serious violent crimes charges. We understand the complexities of Illinois law and will work closely with you to build a strong, strategic defense aimed at protecting your rights and minimizing the impact your manslaughter charges have on your life. Involuntary Manslaughter Lawyers in Chicago, serving all of Cook County, Illinois. An involuntary manslaughter charge in Chicago, Illinois can turn your life upside down. These cases often arise from tragic accidents or unintended consequences, but the legal system still treats them seriously. A Cook County involuntary manslaughter charge can quickly put your freedom, reputation, and future at risk. At Combs Waterkotte, we understand that involuntary manslaughter charges often stem from complex, high-pressure situations, not malicious intent. That's why we take the time to understand every detail of your case, starting with a free, confidential consultation. From there, our experienced team of criminal defense attorneys, law clerks, and paralegals will carefully analyze the evidence, challenge the prosecution's narrative, and build a defense strategy tailored to your unique circumstances. Our goal is always to get your charges reduced or dismissed whenever possible. But if your case goes to trial, we are fully prepared to fight for a not guilty verdict. With over 8 decades of combined experience and a deep understanding of Illinois homicide law, we have the knowledge and determination needed to protect your rights every step of the way. If you're ready to take control of your involuntary manslaughter case and defend your future, contact Combs Waterkotte today at 312-500-HELP or reach out to us online. The sooner you act, the stronger your defense can be. What is involuntary manslaughter in Chicago, Illinois? Involuntary manslaughter is one of the many homicide offenses described in the Illinois Criminal Code. It's charged when a death is caused accidentally, but still came as a result of reckless behavior. The statute, 720 ILCS 5/9-3, says that a person is charged with involuntary manslaughter when a person causes someone else's death unintentionally and without a valid legal excuse by acting recklessly in a way that is likely to cause death or serious injury. As an example, imagine a man showing a handgun to some friends in his apartment. He believes the gun is unloaded, but he doesn't check. While joking around, he points the gun at a friend, pulls the trigger, and kills them. Because he acted recklessly in a way likely to cause injury or death, and killed someone unintentionally in the process, he can be charged with involuntary manslaughter in Chicago or Cook County courts. Involuntary manslaughter of an unborn child. On top of the standard involuntary manslaughter law, Illinois also has a statute on the books specifically for involuntary manslaughter of an unborn child. The statute, 720 ILCS 5/9-3.2, reads similarly. A person can be charged with involuntary manslaughter of an unborn child when they, without legal justification, act recklessly in a way that's likely to cause death or serious injury and accidentally kill an unborn child as a result? Imagine an instance where a man gets into an argument with his pregnant wife. During the argument, he forcefully shoves her, knowing she is pregnant. She falls and, as a result of her injuries, suffers trauma that results in the loss of her pregnancy. Even though the man in this example did not intend to kill the unborn child, he still acted recklessly against someone he knew to be pregnant, and his actions were likely to cause serious harm. He did so without legal justification, and, as a result, he can be charged with involuntary manslaughter of an unborn child. Voluntary versus involuntary manslaughter in Chicago. What's the difference? Because a significant amount of prison time separates voluntary manslaughter and involuntary manslaughter in Chicago, it's natural to wonder what the difference between the two charges is. While the statutes are similar, the difference is that voluntary manslaughter has a bit more intent behind it. First of all, there's no law on the books in Illinois actually called voluntary manslaughter. The Illinois homicide laws were reorganized in 1987 and 2009, and the law that was once called voluntary manslaughter is now called second-degree murder. Illinois' second-degree murder statute reads similarly to other states' voluntary manslaughter statutes, so the terms are sometimes used interchangeably. While involuntary manslaughter includes acting recklessly and causing a death accidentally, Illinois' voluntary manslaughter, or second-degree murder, statute pushes culpability a bit further. It covers instances where the individual acts under sudden and intense emotion caused by the person they killed, but the killing was accidental. The individual believes they were using justifiable force under the law, but they actually weren't. Imagine a Chicago man gets into an argument with a neighbor. The neighbor angrily steps toward him and raises his voice, but does not make a threat or display a weapon. The man, believing he's about to be seriously harmed, pulls out a gun, shoots the neighbor, and kills him. Because sudden passion and a belief of self-defense are involved, the action rises above mere recklessness and can be charged as voluntary manslaughter or second-degree murder under Illinois law. What are the penalties for involuntary manslaughter in Chicago, Illinois? Both involuntary manslaughter and involuntary manslaughter of an unborn child are charged as a Class 3 felony in Chicago, Illinois. A Class 3 felony typically carries a prison sentence between 2 and 5 years, but in some involuntary manslaughter cases, the offender may be subject to an extended term. Extended-term prison sentences in Chicago and Cook County felony cases arise from offenses where aggravating factors are at play. Some of the aggravating factors that may extend an Illinois involuntary manslaughter prison term include offenders with prior felony convictions, offenders who were on probation or parole at the time of the incident, offenses against people who are 60 years older, physically disabled, or minors, offenses that occur in or near a school, place of worship, or nursing home, offenses in which more than one person is killed. Beyond potential prison sentences, an involuntary manslaughter conviction in Chicago, Illinois can come with a fine up to $25,000, mandatory supervised release up to 1 year after the conclusion of the sentence, and the loss of one's firearm owner's identification card, FOID. Criminal defense strategies against involuntary manslaughter charges in Chicago. At Combs Waterkotte, we've defended Chicago and Cook County residents from the entire spectrum of Illinois homicide charges. The following are some of the criminal defense strategies we've found most effective in combating involuntary manslaughter charges. Lack of recklessness. One of the most effective defenses against involuntary manslaughter is showing that the defendant did not act recklessly. Illinois law requires proof that the accused consciously disregarded a substantial risk. If the conduct was merely accidental, negligent, or a mistake in judgment, it may not rise to the level of criminal recklessness. Demonstrating that the defendant acted reasonably under the circumstances can lead to reduced charges or even a full dismissal. Self-defense or defense of others. In Chicago, involuntary manslaughter cases, if the defendant was acting to protect themselves or another person, this may serve as a legitimate defense strategy. Even in cases involving unintended death, self-defense can justify the conduct if the force used was reasonable under the circumstances. In some cases, a claim of self-defense or defense of others may reduce the severity of the charges or lead to a dismissal. Violation of constitutional rights. If, during their investigation, Chicago or Cook County law enforcement violated the defendant's constitutional rights by conducting an illegal search, coercing a confession, or failing to provide Miranda warnings, key evidence may be suppressed. Without that evidence, the prosecution's case may fall apart. Mistaken identity or wrongful accusation. In some Chicago manslaughter cases, the wrong person is charged with the offense. Eyewitness misidentification, faulty police work, or assumptions made during an investigation can lead to wrongful accusations. The defense may present an alibi, surveillance footage, or other proof showing that the defendant was not responsible for the alleged conduct. Insufficient evidence. Every criminal case depends on the strength of its evidence. If the prosecution relies on weak witness testimony, inconsistent statements, or unreliable forensic evidence, the defense can challenge the credibility of that evidence. Raising reasonable doubt about what actually happened can prevent the state from proving guilt beyond a reasonable doubt. Negotiating reduced charges. Even when the evidence is strong, an experienced defense attorney may be able to negotiate a reduction in charges with Cook County or Chicago prosecutors. For example, a case initially charged as involuntary manslaughter could potentially be reduced to a lesser offense, like reckless conduct, depending on the facts. Strategic negotiations with prosecutors can significantly impact the penalties a defendant ultimately faces. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.